Namaskar and welcome to Study IQ. I am your friend Rahul Saigaonkar. The agenda for today's discussion is connected to Indian polity. Under the domain of polity, we are going to discuss about Indian judiciary. Today's discussion is a very important template, or I can say it is a ready-made content made for UPSC civil services aspirants by the parliamentary panel itself. Indian judiciary is a very relevant and an important topic for UPSC civil services mains. Many a times, mains questions appear where you are asked to analyze the issues with Indian judiciary and suggest measures or reforms to improve its working. In this video lecture, we are not particularly going to focus on the issues, but we are going to discuss about some of the important measures or recommendations given by this parliamentary panel to improve Indian judiciary, especially the higher judiciary. You can see the heading: parliamentary panel recommends many measures like senior judges to disclose asset, take rotational policy, etc. So here we'll discuss the report comprehensively. Make a note of these measures or reforms. You can use them in your answer writing. So without any delay, let us begin our interaction. But before that, there is a huge news. Our year's biggest sale, that is Independence Day sale, Azadi Ka Amrit Mahotsav sale, is on. It will be available till 15th August, where you will be getting maximum discounts. If you use the code Rahul Live, you will get discount on the P2I program. The final price would be 26,999. You do know P2I includes prelims test series, mains residential program, the entire program, the comprehensive idea itself. Apart from that, whatever option you choose during this Independence Day sale, if you use my code Rahul Live, then you will get additional discounts. The entire optional program would be just 13K. So do it now. Just go to our website www.studyiq.com. You'll get all the information there. Enroll. I'll see you in the class. All right. Let's begin our discussion. As I told you, our interaction is about a parliamentary panel. This is the Rajya Sabha's departmental related standing committee, which is connected to the Ministry of Personnel, Public Grievances and Pensions. It is chaired by Sushil Kumar Modi. They recently submitted a report, 133rd report on judicial processes and their reform. This is the report where they have recommended some of the changes or what changes can be brought to improve the performance or the working of Indian judiciary, especially the higher judiciary. When I say higher judiciary, that is High Courts and Supreme Court. All right. Now, let's talk about these issues and what are the recommendations. We'll talk about individual issues. First one, the report has highlighted that there is a problem of lack of social diversity in representation of judges at the higher level, especially judges in the High Court. Now, you do understand Indian society has to be represented there also, right? But what the committee has observed is there is a lack of representation in the higher judiciary as judges, especially women and minorities in higher judiciary. Their number is abysmally low. Now you must be thinking, sir, why does this happen? Or you must have a question, sir, is there reservation at higher judiciary also? The answer is no. How do the appointments happen? The appointments happen according to Article 124 for the Supreme Court, Article 217 for the High Court. I would appreciate if the aspirants remember these. The original position was such that it was under the domain of President. The President of India, they would recommend the appointment of judges to the High Court and the Supreme Court by consultation with the Chief Justice of India. However, after the 3 judges case, now we have a setup where the judiciary itself appoints the brethren judges. We have a collegium system. So what is the actual procedure that we follow right now is whenever there is a 6-month vacancy, then the collegium, it starts scouting. Please remember, collegium, it consists of Chief Justice of India plus 4 senior most judges when it comes to appointing judges to Supreme Court, and here Chief Justice of India plus 2 judges when it comes to appointing the judges to the High Court. So whenever there is a pendency, the collegium, it sits together, it starts scouting, it takes the names, then looks at their merit, their record, their integrity, their track record, and then eventually passes them or sends to the Law Ministry. The Law Ministry has one qualified bidder, or Law Ministry can send it back once to the collegium. But if the collegium reiterates the same recommendation, then the government has to pass this idea or recommendation or advice to the President of India, who would appoint these judges. That is the procedure as of now. Meaning there is I would say there is a very little involvement of government or Ministry of Law. It is right now in the hands of judges themselves. The collegium consists of only judges, Chief Justice of India, and the senior most puisne judges. All right. Now, what is happening? What is happening? The committee has observed that since the collegium has started appointing, there is a problem. There is a problem from a very long time that the representation is not equitable, or some sections are not represented. Especially women judges are very low in numbers. Judges from different castes are very low in number. And I'm reiterating that there is no concept of reservation in higher judiciary. Clear? Now, if you look at these numbers which have been provided, in the last 5 to 6 years, the number of judges who are appointed to the high courts, it is up to the tune of 601. 600 judges. Now, out of these judges, 457 judges are from the upper caste, that is general category. The number of women are 91, very less, even less than 25%, whatever the appointment number. Now, if you look at the judges from other castes, SC, ST, and OBC, the number is again abysmally low. Now, I'm not telling that there has to be some sort of reservation at the higher judiciary. Please try to understand this is a discussion going on from the academic perspective, but from common sense, one does understand that there needs to be better representation of marginalized sections and women here, and that is what the committee has also recommended. Now, this issue has also been acknowledged by the collegium. In 2017 itself, the collegium had acknowledged that there is not adequate representation of some of the sections, especially women and marginalized section, and the collegium system, it stated that for appointment of higher judiciary, for appointment to judges of higher judiciary, only merit and integrity shall be the prime criteria, but they will keep in mind regarding this representation, and they would give more weightage towards women and marginalized section going forward. All right. In fact, some of the members from this particular committee, they highlighted, or they give a note there suggesting that adequate constitutional amendments can be made to give representation to SC, STs, OBCs, and higher judiciary, some sort of reservation. But I would say that would open a whole Pandora's box, another can of worms, where again, to higher judiciary, to some specialized jobs, you do know reservation as a concept by Supreme Court also, it has been rejected. Wherever merit, integrity, right, all those aspects are prime, there the concept of reservation, there is a long debate going on. But right now, understand, there is no reservation concept at the higher judiciary. The reservation, the appointment is finalized by the collegium system, and collegium system has acknowledged that we will keep this in mind going forward. So let's hope that in the upcoming years, when we look at the numbers, then we would see some appropriate appointments going forward. All right. So this is the first recommendation. We need diversity. And now you are thinking, sir, what is the need of this diversity? See, diversity is needed at every aspect. Diversity in judiciary is extremely important, because say if a constitutional bench is sitting, then a dissenting judgment may come, a dissenting idea may come, dissenting verdict may come, right? So you need it is always better if we have diverse opinions leading up to proper judgment, isn't it? That's why diversity is a very good criteria. Now, the second recommendation is regarding the regional benches. Now, right now, you do know that Article 130 of Indian Constitution, it suggests that the seat of Supreme Court is New Delhi, but we can set up regional benches, meaning with the approval of the president, we can set up regional benches of Supreme Court. As of now, there are no regional benches of Supreme Court, meaning if I have a case, right now I have a case filed in my district. Now from my district, it will go to High Court if it is eligible. From High Court, if I have to go on to appeal, then I have to reach Delhi. That means I have to travel from my place to Delhi. And now I have to hire lawyers from Delhi. I have to stay there, which leads to more and more cost of justice, more and more cost for that particular case. It doesn't make sense, right? So this has been a recommendation which has been pending from very long, and the committee has reiterated again that regional benches can be created in at least 4 to 5 cities in India, especially metropolitan cities. And they have also highlighted that if it is a matter connected to constitutional interpretation, then that should always come to New Delhi. Meaning, if it is a constitutional bench or constitutional matter, it can be decided by Delhi bench itself, the main bench, but some other appellate matters, they can be transferred to these regional benches, which will lead to more access of justice and quick and timely justice as well. The third recommendation is connected to possibility of increasing the age of the judges. Now, you do know right now at the higher judicial level, the higher judiciary age limit for High Court, it is 62. For Supreme Court, it is 65, the retirement age. Now, this is going on. This debate is going on for very long now. Can we increase the age of these judges? We always talk about shortage of judges. So many cases pending in India. More than 3 crore cases are pending, including the lower judiciary, of course. So there is a lot of pendency of judges. So if the retirement age of judges is increased, then with their experience, right, with their expertise in legal matters and longer tenure, they can dispose of many cases. This is one of the arguments. But again, it has to be taken with a pinch of salt. We have to take it with a little caution. Now, if we look at the age limit for higher judiciary in different countries, in USA there is no limit. If a judge is fit and fine, healthy, then they can continue for long, and they can take the senior status as 65. Now, once they take senior status, the workload would be reduced. For other countries, it is somewhere around 70. For UK, it is 70. In Canada, it is 75. The retirement age of judges, only judges. Australia, it is 70. In Germany, it is 68. Now, by this logic, we may think that, okay, we can increase this age maybe by a couple of years, 2, 3 years, 5 years. We can maybe reach up to 70. Now, if we ask the government thinks that increasing age has its own issues. Yes, because again, we need to talk about the cognitive powers of the judges. There is merit on one side, because with the experience, with the more and more experience, with sitting for more and more cases and giving more judgments, legal expertise will excel, more wisdom, of course. But on the other side, health and cognitive issues have also they also need to be catered into. But these days we talk about the living age itself increasing. There are so many medical advancements, medical technology is enhancing day by day, so longevity is also increasing. So it's a seesaw battle or a seesaw debate as of now. All right, looking into the longevity and advancement in medical technology, we can increase their age of retirement for Supreme Court judges, again, appropriately. There is no number which has been suggested, but with the coming of information and communications technology, day by day we are talking about 5G, artificial intelligence, and that their impact on judiciary as well. We have to look at this particular aspect from a point of caution for sure. All right, so no specific recommendation has come to increase age to this particular level. Such recommendation has not come. They have said, while increasing the age of retirement of judges, the performance of judges may be reassessed based on their health conditions, the quality of their judgments, number of judgments delivered, etc. Taking all these into cognizance, we can increase the age of retirement. But again, no number has been cited. Now, the next issue is with respect to vacations. Now, this is a very interesting idea. Vacations in Supreme Court and High Court have been very high. Now, when I came to know about this first time, I think almost a decade back, I laughed a lot. All right. Now, to put it in a very simple terms, you do know children, they have summer vacation. Now, very similar to how school children have summer vacation, the judges, they also have summer vacations. Surprising, isn't it? Right. Now, if you look at the average number of working days in Supreme Court and High Court, it comes down to about 210, 220 itself. If you see Supreme Court's average working days in the last 3 years, it is somewhere around 220 itself. And High Courts, it is much lower than that, average of 210 days. Now, you must be thinking, we have 365 days and the judges are working only for this much time. Any average person also works for approximately, I would say, 240, 250 days only. Why? See, if you're a software professional, you do know that you have 52 Sundays, 52 Saturdays. That means 104 days are already gone. So you're left out with about 250 days. And in that, about 10 days of festival holiday. So 230 to 240 days. But with judges, there is one more issue. And I would say that issue is a colonial hangover. Right from the colonial times, there was always a summer vacation for judges. And during this summer vacation, the entire judiciary, especially the civil matters. When I say vacation, it is only for civil matters, not for criminal matters. Criminal matters will be running. Civil matters, vacation is applicable. And that vacation was earlier, it was 10 weeks. 10 weeks means 2.5 months more than what children get for school. Right? So, this is a very interesting aspect. The Department of Justice, it has reduced from 2013, if I'm not wrong, it is now 7 weeks. In fact, when I inquired about the Karnataka court itself, right? In Karnataka, even it is available at lower courts. In lower courts, summer vacation in Karnataka is about 1 month. They also have another vacation during Dasara around 7 to 10 days. So that means 30 to 40 days vacation itself. Now here the committee has recommended this number should be reduced. Why? It's plain and simple. See, if I have filed a case, I would want my case to be processed and disposed of quickly. But if the judge is not available, say for one month, 1.5 months, then I would be getting dates and dates. And I hope you remember that Hindi dialogue from Sunny Deol, right? Tariq pe tariq. That happens. All right. So that is why the committee has recommended the number of vacations, or at least some sort of rotational vacation policy, can be brought. First of all, it is a colonial legacy because of which the judges, they get vacation en masse. That means during summer, complete 1 month, 1.5 month vacation is there. Now, one idea was already suggested by the former Chief Justice of India, Shri R.M. Lodha. He suggested that instead of all the judges going on vacation at once, judges can create a roster and they can take their own vacation or their own leave on a rotational basis, so that judges would be available and judicial work would continue for 365 days, or I would say for at least 300 days, right? That's the basic idea. All right. So when I say rotational vacation policy, not all the judges going on vacation together. Right now also, even if there is a vacation, a special vacation judge is also allotted for urgent matters during those vacations. Please note that. All right. So rotational vacancy is one of the recommendations. Apart from that, there is another very important recommendation of mandatory disclosure of assets. Now, this is applicable for everybody. You do understand mandatory disclosure of assets is applicable for anyone who's filing nomination for elections, for MPs, for MLAs, anybody who's got a ticket, who's filing a nomination. So it does make sense. It should be applicable even for the judges, isn't it? Every year, the annual returns and their assets, they should be declared, so that we understand that if it is a public functionary, there has to be some sort of transparency, and I would say it would help eventually in curbing the corruption, right? So mandatory disclosure or declaration of assets for Supreme Court and High Court judges. Yes. Apart from that, there is one more very important recommendation about annual reports. Now, annual reports by the courts. Now, this is a very important recommendation. For every company, we do have this annual report, right? Every company, it releases an annual report suggesting that this was our performance in the last year. Quarter by quarter, we grew by this, or we incurred these many losses. Now, very similar to that, judiciary must also submit annual reports, and it is followed at lower courts. It is followed at many courts. It is followed at Supreme Court level also. But the committee has observed that only some high courts, they publish their annual reports. And now they have recommended that Supreme Court of India, they must issue necessary directions that all the high courts, in fact, all the courts in India, they must submit annual report, which is going to be really helpful in enhancing transparency and understanding the efficiency of Indian judiciary itself, isn't it? So annual reports to be published each year, such direction has to go from Supreme Court. Let's wait and watch whether these recommendations, whether these suggestions would be ultimately implemented or not. But you do understand these recommendations make a lot of sense. Make a note of these. You can use them in your answer writing whenever questions are asked about analyzing Indian judiciary and what are the requisite steps that are needed. These are the steps that are needed in bringing transparency, accountability, and efficiency in Indian judiciary. All right. Now, if there is any update on implementation of these, we'll discuss that again on Study IQ. That's it in this particular discussion. If you have liked this discussion, you can always follow me on the ID @RahulSai22. Thank you for watching this again. Jai Hind.